Welcome to the Small Business Contracts Coach.
Hello, everyone. Welcome back to the Small Business Contracts Coach with attorney Darryl Shaper of the fixed fee law firm PLLC. Darryl, how are you doing?
Doing great, Sean. Great to see you.
Same here, same here. Darryl brings 30 years of business and legal experience helping Texas entrepreneurs get protective, plain English contracts at fair and predictable prices. I'm Sean O'Connor, and today we're talking about independent contractor agreements in Texas. Darryl's going to explain what they should cover, where small businesses get surprised, and how to avoid expensive misclassification problems. So this is sure to be super informative. Darryl, right out of the gate here, what makes an independent contractor relationship different from a normal employee relationship?
Well, the biggest factor is employees are massively more expensive to a company than an independent contractor because of all the benefits and payroll taxes that you have to cover on behalf of an employee. Whereas an independent contractor is responsible for their own taxes, responsible for their own healthcare benefits, etc. So I always recommend to my clients, and I have a lot of startups and new companies, for the first year or two, the more you can hire independent contractors rather than employees, it gives you the flexibility to keep your costs lower, move faster in terms of hiring and firing. And that's another key difference between independent contractor agreements and employees. Employees are more likely to sue you if they get let go, et cetera. And so there's much more risk with hiring an employee.
Got it. And I'm guessing some of this varies state to state, but in Texas, what are the most common gray areas that cause confusion about whether someone is truly a contractor? Are there red flags or key indicators?
Yeah, realistically, small businesses don't need to worry too much about whether somebody is an independent contractor or not, because the cases that have been filed where people have been reclassified from independent contractor to employee mostly involve large companies. Microsoft is a great example where they had all these independent contractors up there in Seattle. They were treating them very similarly to the way they treated their employees, but they didn't get the gold-plated healthcare benefits that Microsoft employees got. They didn't get stock options. They didn't. And so they sued and they ended up winning and got reclassified. UPS had a large case similar to that with the drivers. When you're a little bitty company, the key things you need to think about is the employee needs to bring their own equipment, like their own laptop or so forth to the equation. You don't want to set their hours super specifically. You just give them an assignment and let them do that assignment when they get it done. If you kind of stay away from those big gotchas, you're very unlikely to get busted as a small company and have an employee reclassified, with one super important caveat. So let me give you that caveat, which one of my clients got burned, where he hired a guy, verbal agreement that the guy is an independent contractor, no written contract whatsoever. Guy works for him for about 6 months. He tells the guy, you're not doing a great job. I think we're going to have to part ways. The dude claimed, I'm an employee. I'm going to file for unemployment. You owe me X, Y, Z. And because it was all just verbal and there was nothing written that clearly established that he was an independent contractor, he had to settle.
Oh, wow. Well, so my takeaway there, of course, is make sure there's an agreement in place to make things clear.
Yes. As a contracts lawyer, I have to say, please don't do agreements with independent contractors, employees, or a customer that are just a handshake deal. I believe people should honor their word, but sadly, that could come back and bite you.
Yeah. Well, that I was thinking about. You mentioned that being a huge no-no, but I'm wondering what actions or even habits can still create problems if the day-to-day relationship looks more like employment. You mentioned like, okay, if I'm dictating hours, that's probably a red flag.
Yeah, dictating hours, providing them with a bunch of equipment. So
Oh,
let's say you had a car wash, mobile car wash business. And instead of sending the folks out there with their own pressure washer and rags, you provided all the equipment associated with doing that job. That is likely to be a risk factor. And
mhm.
especially if you made them pay you for use of that equipment or something like that, that probably is a red flag that would cause you to potentially have them declared an employee. Um, those are the two big ones that I can think of.
Mhm.
Um, so I really think those are the ones that are most likely. If you get way too detailed into managing their day to day work, that's a risk factor as well.
What about having a desk for them? If it were, you know, the kind of project where they have an office, and I like, if I were the independent contractor, I'm coming in, I'm working for your company, and you're like, hey, Sean, I got a desk for you over there. Like, is that an issue?
I don't think it's totally an issue. That's into a gray area, I would say. If they said, Sean, you need to be here at 9, you
Hmm.
got to sit right there. Your breaks are from 10:10 to 10:30 in the morning, and then your lunch hour is exactly this time, and I'm expecting to see you at that desk, except for
Yeah.
these times that we've designated, you're probably in a risk factor. If
Right.
you said, hey, Sean, come on down to the office, I have a desk for you if you want to use it. You don't have to use it. As long as you get your work done and get the projects I've assigned to you done, we're all good. You're fine.
Yeah, yeah. Now, when you're reviewing uh, independent contractor agreements for your clients, what are the first things you're looking for? Are there specific sections of the document that you're going to be like? Is your go-to like, okay, these are the most important, or things that you've seen that are often wrong?
Yes, there's one and two that are most important by far. And then I kind of have a third one that may be pretty good. So, number one, I want a super easy out. If you're not working out, if the independent contractor is not working out, I want easy rights to terminate our agreement
Hmm.
on, 10 days or 30 days notice without with or without cause. Very, very important that I can terminate for convenience is what it's
Yeah,
called.
just
So
on
I
a
want the
whim.
right because I don't want to get into an argument about whether I had the right to terminate you or you did something wrong. It's just I terminated you for convenience, right? So that's number one,
Mhm.
easy out. Number two is absolute clarity that the intellectual property or the work product created by the independent contractor is owned lock, stock, and barrel by the company that contracted for that intellectual property. Okay, that's number two. And then, sort of, number three is compliance with laws and regulations. So, again, I used the mobile car wash example because I recently had a client that we were hiring independent contractors for that. And he came to me and said, hey, the Clean Water Act doesn't allow you to discharge the soapy water into the gutters. And he said, I want to put some really specific language in there around that. And I said, we can totally do it, but it's belts and suspenders, as we say in the law, because already in your contract is a provision that says the contractor knows of, is responsible for knowing, and will comply with all laws that apply to the work that he's doing.
Oh yeah, good point. Good point. Yeah, the belt and suspenders thing that could turn into dictating terms that then to put you in this gray area of whether they're an independent contractor in the first place. That's interesting. Um, Scope of work. I've done a lot of project work in my career, and scope is where things get messy, scope creep. So what language helps keep the work, the deadlines, the deliverables, all of that clear, without turning the contract into a 20-page user agreement type of situation?
That's such a great question, Sean. I regularly and on previous podcasts, I've talked about this where you have frequently an MSA when you're providing services of some kind, and then you have the statement of work. The scope of work or statement of work is almost always where the problems arise. All
Mm.
right. So, my key advice here is your marketing and sales people are going to put all kinds of fancy language describing what you're going to do for somebody, right? Even if you're the independent contractor and you're trying to hire me to, build a website for you. Well, the danger is over promising in that scope of work if you're the provider of the services, and if you're the person booking the services, then you want clarity about what's being delivered. One
Hmm.
sort of catch all phrase that is quite helpful that you can put it into a contractor agreement is it's done in a professional and workmanlike manner in compliance with the standards of the industry. That covers an awful lot when you're booking an independent contractor, right?
Yeah.
Professional and workmanlike manner. Now, on the other hand, when I'm sitting there as an independent contractor, what does professional and workmanlike mean? Those are sort of subjective terms. So it depends kind of which side of the equation you're representing on how you want to deal with it. But in general, avoid adjectives, avoid loose language that is difficult to interpret, avoid deadlines that are absolutely hard deadlines, unless there's a caveat that says if the client isn't helpful or causes the delay to the deadline, then I get an extension based
Yeah.
on the fact that the client was slow.
This is great. I mean, I really have been, I've worked in this space quite a bit. And so it's interesting. I've been on both sides of it, and it's like, ooh, did I lock myself into a too difficult of a deliverable? But, and it comes down to payment too. So, you get into some dispute as to whether the work was professional and workmanlike, and, payment dispute develops, which is pretty common with contractors. What terms tend to matter most around invoices, timing, late payments, maybe, or what happens if the client doesn't accept the work? What happens there?
So this is, again, you're going to typically turn to the statement of work to see if the
Mm.
deliverables were done. But in a services agreement or an independent contractor agreement, one of the clauses I frequently like to put in there is if you deliver the work and the client doesn't object within 10 days with exactly what was unsatisfactory about the work in writing, then it's deemed accepted and they owe the bill. Okay. So that's an important way to protect you if you are an independent contractor, is to have a deemed acceptance after a reasonable time period. So that's sort of idea number one that I would say.
Got it. That's good. And this next question, you mentioned, ownership, work for, I don't know if you use the term work for hire, and I'm not sure I'm using it right, but ownership is obviously a big topic, and especially for marketing, software design, content work, right? So how should the contract handle who owns the work product and what the contractor can reuse later?
Well, if they have some pre-existing IP that they're incorporating into the work product,
Hmm.
often what they give is a perpetual license to that
Ah,
pre-existing IP, and they have to call that out. So that's usually how that's handled. And they call out which things they're licensing to you instead of giving you fully. But
right.
in general, I'm going to push back on that. And I'm going to say, hey, look, there's not some element of software that I need license from you. You give me ownership of this lock, stock, and barrel. And there's no question that I own it, because that license factor has some degree of risk to it. Not super high, but some.
Yeah. Well, and a lot of this, like you said, let's not do a gentleman's agreement, and let's get it in writing. Let's use language that's clear in the ways that we want it to be clear. And then, okay, something goes sideways. We're in now the space around liability and insurance, which often gets ignored until, again, something goes wrong. How do you approach clauses that deal with responsibility, damages, and whether the contractor should carry insurance?
So, depending upon what kind of space it's in. So,
Mhm.
example again, back to the car wash, mobile car wash. We did not require each of them to have insurance because it's a relatively low income job. That's sort of unreasonable. On the other
Mhm.
hand, you're hiring an independent contractor to do um, data security for your company. I think I might want that guy to have insurance
Yeah.
because if they mess up the data security and I have a big data leak, that could be extraordinarily costly to my company. And so I'd want to have general liability insurance. The standard here is 1 million per occurrence, 2 million combined. That's pretty standard, and almost every independent contractor worth their salt can go get that level of insurance, general liability, relatively inexpensively.
Yeah. No, and I've had to do that, and you're right. It was not a difficult thing to do. The insurance company was happy to take my money.
They will, and I don't know if you remember what you paid, but it's really not that bad.
No,
It's
no, no. I'm of
it's
course
not,
kidding, but it was not difficult to absorb at
yeah.
all. So, um, I'm wondering. We're coming up on our time, but I'm interested in there's a lot of just resources online and templates, agreements that people are Chat GPTs of the world, right? Are there places where if I'm using, let's say, more of a generic templated kind of agreement, are there any small fixes or things that people should be looking for that you've seen that just by some tiny tweak you can avoid some major headache? Have you seen anything like that where you could say, hey, look out for this or that?
Well, I have one pretty interesting idea. So, in all of our contracts, including independent contractor agreements, we put in what I call my three-layer cake of dispute resolution. There are many law firms who have both a transactional side, which is what I do, and a litigation side. So they
Mhm.
know if you get into a dispute, you're likely to hire them for litigation. I don't do litigation at all. So I'm going to be totally straight with you that litigation, the only winner is the lawyers. It just takes so much time and it costs so much money. So what we put in is 30 days. You commit for 30 days to negotiate as good humans in good faith with each other to try to resolve this dispute. If you can't resolve it in 30 days, you go to mediation. You agree to go to that mediation and show up in good faith, and
Yep,
80 to 90% of disputes can get resolved in a day in a mediation in business to business.
that's great.
Last but not least, if you still 60 days in can't get it resolved, now you're only 60 days in. You go to a arbitration with a single arbitrator under the rules of the AAA, and on the 61st day, your thing is decided.
Right.
Much cheaper, much faster than litigation.
That's awesome. This is super interesting. And of course, we're, as usually happens, we got to cut short. So, Darryl, thank you. Thanks for this convo. Good to see you. I know we'll talk again soon. And for those of you listening, this wraps up the episode of the Small Business Contracts Coach. And to learn more about independent contractor agreements and the fixed fee contract help for Texas small businesses, visit fixedfeelawfirm.com. And as always, don't forget to like or leave a review or subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.